Hi, folks. This is Kip Malek from Malek Malek. Today I'm going to be talking about time, and this comes up. And the reason why I'm going to talk about this is because when I go to these hearings and when the clients come in, this often is a problem. And what I mean about time is the time between the injury and first going to get medical treatment, the time between the injury and filing the claim, and then the time between the injury and seeking legal representation. And each of these instances brings its own problems to the claim when the time between those events is elongated. So, in the first instance, the time between the injury and seeking medical treatment. What could happen is, let's say you have an injury at work and it involves lifting a box, and so it's maybe a lumbar sprain strain type of situation, a lower back injury, and you lift up this box, you feel some pain, you work the rest of the shift, you think it's going to go away, and which isn't unreasonable. So you wait a couple days, 2-3 days, then you go to urgent care, ER, or your primary care physician. In that instance, that's probably okay. But one of the things that could come up if you let it go beyond that, let's say a couple weeks or a month, is that you can have an intervening event. And for example, you could have a minor motor vehicle accident, which in any other instance would not cause any kind of injury. So let's say you just get bumped, or you drive over a curb, or you're backing out of a parking spot and about 1 mile per hour, and you hit somebody who's also just standing, their car's just there. Once that, if that were to happen, and you go to ER, urgent care, primary care provider, and they document that, that's going to throw some mud into what caused the injury. Was it the lifting of the box, or was it this minor motor vehicle accident? And that's just one example. But the more time you allow to elapse between the injury and going to your medical care provider, urgent care, ER, etc., you have more of a chance of that happening. And also you give the employer attorney more of an opportunity to say, hey, this comfort and conditions and issues that you are having right now, it has nothing to do with this minor lifting of the box, but rather it's something else. So we want to remove that possibility for that argument. So you want to keep the time between the injury and first reporting your work conditions as little as possible. Keep that as small as possible. The second thing is the time between your work injury and actually filing a claim. And with this, I'm just going to say, and again, this bears out through my experience with clients and hearings, is honestly, you really got to make a decision once you go to your medical care provider whether you're going to pursue this as a workers' comp injury, or whether you're going to pursue this not as a workers' comp injury and have everything covered through your personal insurance. Because if you're thinking, okay, I'm going to pursue this through my personal insurance through, a number of months, and that's how it goes. And then after about 5 or 6 months, you're like, you know what? I think I'm going to pursue this as a workers' comp claim. In Ohio, you do have a year now. It used to be 2 years, but you do have a year to file a claim. But by that time, you're going to have medical records that say whatever excuse you gave for the injury, if you didn't say it happened at work, they're going to be chock full of those reasons, and then it's going to be real high road, real high hill to overcome to prove that whatever issues you're having are due to a work injury rather than something else, and then it really casts doubt on your credibility to either a hearing officer or a jury if it were to go to trial. And then the final thing in terms of time is the time between the work injury, filing the claim, and then obtaining legal representation. Some people, I don't know if, and I don't know if, the thing is, before I was an attorney, a workers' comp attorney, I honestly had no idea that such a thing existed in Ohio. I mean, I had an idea because this is what my brothers and my dad did, but I didn't really understand, all through. And I'm from Ohio, but I've worked in other states and stuff, and I didn't really understand what it all entailed, and I had no idea that everybody essentially had to have workers' comp coverage. And so I think that's probably the case with about 99% of folks who get injured, unless they've had a prior work injury, have no idea how that such a thing exists as a workers' comp system. So they're kind of, when you get injured, you go to your primary care provider, and then they'll, a lot of times if you go to like Mount Carmel or an Ohio health provider, ER, urgent care, they'll send you to occupational health or work health. You'll get a FROI filed, and it seems like everything's getting taken care of because your risk management company will be contacting you. But bottom line is, there's a lot of things. They're not going to be aggressively pursuing treatment that you need. They're not going to be appealing things that need to be appealed. Your physician, your workers' comp doctor might request conditions that aren't supported medically, that would require further causal support or evidence to get them allowed. They go to hearing, they get denied. The client doesn't understand that they have to go to hearings, so they don't. There's a lot of issues that can arise. The client, the doctor doesn't pursue aggressively various diagnostics to diagnose the claim, or they'll just do a series of physical therapy, and then that's that. So for these clients who come to us, they'll come to us, some folks come to us 6, 7, 8 months after their initial work injury, and by that time always Malek Malek does their utmost getting as much compensation and medical treatment that we can, but by that point we will do everything that we possibly can, but a lot of what we're doing is unraveling various errors and mistakes that were made by different people, and had that client come to us like a month or a few weeks after their work injury, they would have had a much better outcome. So if you do have a work injury, and I'm always telling on these videos, it's gonna pay dividends to get a workers' comp attorney. It's absolutely worth it. And if you don't, unless you have like the most straightforward, simplistic, easy claim, you're going to run into problems, and it's just not. This is another example I give, and I think this makes a lot of sense. If I was, this stuff isn't rocket science rather, but working on a car isn't necessarily rocket science either. But if you ask me, hey, fix this car over here, I have no idea what I'm doing, and it is basically rocket science to me. Likewise, if you're presented with this workers' comp system, it's not complicated, it's not rocket science, but you, like me with cars, it's basically like rocket science. So that's why it behooves you to get an attorney. So with that said, again, you want to keep the time as short as possible between the injury, seeking treatment, the injury, filing the claim, and then the injury, seeking legal representation. I hope you've found this video helpful. If you have questions, concerns, etc., please either give me an email or give us a call at Malek Malek, and thank you.